The plaintiff also has to show that they suffered injuries for which damages can be assessed. So exceptions to informed consent, we talked about emergency situations, therapeutic privileges, and patient waiver, prior patient knowledge. Oops, sorry. Okay, so therapeutic privilege, this is an exception to informed consent, and it only applies when disclosure of the information itself can pose serious and immediate harm to the patient, such as prompting suicidal behavior, self-harm, harm to others. Patient waiver is when a patient waives any rights to informed consent, that they will accept any and all treatment presented to them. So, for example, you are in a research study and it's double-blinded. So you might get the treatment or you might get the placebo, and you consented to both, but you don't know which one you're getting. So the patient's waiving the fact that they have to be asked based on, which they're randomly chosen for. And then the other one is when a patient has prior knowledge of the risk. Okay, so moving on. Accountability for obtaining informed consent. Physicians and independent practitioner has responsibility for obtaining the informed consent. Okay, so technically when a doctor's like, go consent the patient for blood, you cannot be the one who obtains the consent. Now, you can prep them, you can let them read everything, but all the questions and thoughts and then the consent has to be done by the provider. Hospitals have no responsibility for obtaining informed consent unless primary healthcare provider is an employee of the hospital or the hospital knew or should have known of lack of informed consent and took no action. So what that means is they can only go after that provider versus the entire hospital as a whole. So your role. Nurses who are not independent practitioners must know the state laws and continually communicate with a patient regarding procedures and permission. Refusal by a patient must be respected. So you need to know your laws in terms of getting consent, informed consent. So if you look, you Google Ohio Nurse Practice Act, informed consent. Oops, sorry guys. Okay, so in the state of Ohio, the provider of record has to get the informed consent. So I just read through all that. Okay. And then, of course, refusal has to be respected. So even if somebody's breathing down your neck telling you, hey, you got to put in, this G-tube and NG-tube and someone doesn't want it, you can't force them to do it. Nurses have important roles to play if the patient wishes to revoke prior consent. So you have to advocate for them. Already assign informed consent that does not meet the standard of informed consent. So if the form, you read through the form and you're like, this is not a good informed consent form, it's your job to it's part of your job to ensure that you get a different form for them. And if the patient clearly does not understand the procedure to be performed, it's your job to intervene as well. So if someone doesn't understand what's about to happen to them, you really, 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 really want to be, an advocate for them. So there's a blanket consent, a specific consent, a detailed consent. So blanket consent, a lot of times those are used in the emergency room, like, hey, if in case of an emergency, you're giving consent for a bunch of crazy stuff, like, and you'll read in there, I'll be like, blood, because, you know, you're going into an emergency situation. You can't sit there and read and, like, get this long, drawn-out, informed consent. Or there's a blanket consent like, okay, so you're agreeing to a colonoscopy, and if there's a case of a polyp, for consent from you to remove it and biopsy it. Then there's specific consent, which is like for whatever the procedure is, and you cannot do it anywhere else. So if you consented for a right intrajugular vein central line, and that's the specific consent, then you would have to get a new consent if they had a try on the left side. And then a detailed consent will obviously goes into more detail of what they're consenting for. So the signature of the competent patient or legal rep, name and full description of the proposed procedure and who's going to perform it, and then the description of risks and alternative of the proposed procedure. And so if you see the form is not adequate, like it doesn't have the information, like you might get a pneumothorax and we drop this NG, it's really important that you, get a new form. Also, there needs to be description of probable consequences of the proposed procedure. So a really good thing I would say is, like after gastric bypass, I think, making sure that the probable consequences are there. So, dumping syndrome and things like that, so that, people are truly aware of what it means to go through gastric bypass. And then signature of one or two witnesses according to state law. Some places don't need a witness for consent unless it's a verbal or telephone order. Some do, even if it's signed, and that just depends on your law. Nurses should remember witnesses are not required to make consent valid. Consent may be withdrawn at any time. Consent forms are not conclusive and can face challenges like coercion and incompetency. And then nurses should check for forms that they address the proper procedure. Handwritten notations on consent forms may be binding. And so if you jotted something down on there, it's part of the medical record. Consent forms are considered to be valid until withdrawn by the patient or caregiver, sorry. So the correct person must consent to the procedure and therapy. The wrong signature makes informed consent invalid. Competent adult is typically 18 years old, and according to state law, only that adult can give or refuse consent. The legal guardian or representative is the person legally responsible for giving or refusing consent for the incompetent adult and has a narrower range of permissible choices than if he or she were deciding for himself. So, so if you're like a guardian for an adult, you can consent or not consent to certain things, but it's a way narrow choice. And refusing care, also, your choice is narrowed with that if you are an adult guardian. Minors or children under 18 years old, parental guardian consent is necessary for them unless the emergency doctrine applies or the child is considered an emancipated or mature minor. Also, if there's a court order to proceed with the therapy, and the law recognizes the minor as having the ability to consent to the therapy. So what that means is, and there's like a certain age, it just depends on, so it's like age of consent, it depends on the state. Usually it's like 13 or 15. So for example, if you need a kidney transplant and you're 15, and you are just like, I don't want it, I don't want to go through all that, I'm scared of the surgery, I just want to continue on my dialysis. Your parents might not be able to overdrive your decision to not do it because of the fact that you have to also consent, at a certain age. And also ethically, most hospitals would never touch an unconsenting minor. Emancipated minors are under the legal age, no longer under their parents' control and regulation, and are managing their own financial affairs. A pregnant minor is considered a legal minor. A mature minor are teenagers between 14 and 17 years of age and may consent to some medical care if they can understand the nature and consequences of the proposed therapy and make decisions for themselves on a daily basis. Informed consent from a minor can be problematic. It can postpone procedure and treatment until a determination is made. In an emergency, proceed under the emergency consent doctrine and maybe seek parental consent.